This courtroom session unfolds in a Michigan district court during a routine morning docket composed primarily of probable cause conferences, bond arguments, and status updates. The setting is one of practical order rather than high formality. The emotional tone in the courtroom fluctuates between composed and mildly strained, with moments of light sarcasm and frustration from the bench. While there are no major disruptions, the judge's tone reflects a low tolerance for tardiness and vague explanations, underscoring the expectation that all participants adhere to the structure and schedule of the court. The judge, though not named explicitly in this transcript, demonstrates a direct and sometimes sharp demeanor. His style is forthright and untonal, often cutting through explanations with rhetorical questions or quick conclusions. However, he allows counsel to speak fully and entertains motions and requests with procedural fairness, even when laced with skepticism. His command of the proceedings remains firm and clear, providing structure to an otherwise flexible docket. One notable case involves Alicia Henderson, who was absent at the time of her scheduled appearance. Represented by Assistant Public Defender Tanasia Carey, the court was informed that Ms. Henderson missed court due to a medical appointment related to her pregnancy. Carey assured the judge that she had spoken with her client and requested a temporary pass on the matter while they confirmed her expected time of arrival. The judge responded with overt skepticism, stating plainly that he had little sympathy in questioning the reliability of the excuse. Nevertheless, he allowed the matter to be passed temporarily, noting his impatience with what he suspected might become a no-show. Despite the judge's curt demeanor, Carey remained composed and professional, working to advocate on her client's behalf under difficult circumstances. The next case called was Dantes Williams. Represented by attorney Hannah Mackey, Williams was present and responded respectfully to the court's questions. His attorney requested that the matter be passed temporarily, pending another bond-related motion to be addressed later in the day. The judge granted the pass without objection, indicating a preference for handling related issues in a consolidated manner. In the case of Marcus Jones, represented by April Orchestum, the tone was more cooperative. Jones appeared in person and explained that he was preparing to begin outpatient treatment at CMA as part of his plan to regain compliance with prescribed medication. The defense requested a month-long adjournment to allow Jones time to demonstrate progress. The judge, after confirming available dates and acknowledging the treatment plan, granted the request and rescheduled the probable cause conference for July 22, 2025. The exchange was calm and straightforward, reflecting mutual respect and procedural clarity. Overall, the session moved at a steady pace, with each matter receiving attention appropriate to its stage. While the judge's tone ranged from sarcastic to cooperative, it remained effective in keeping the docket moving and ensuring legal expectations were upheld. Counsel maintained professionalism throughout, managing both absent clients and logistical updates with steady focus. This session offers a glimpse into the everyday demands of judicial oversight, where structure and discretion coexist under the judge's careful direction. Welcome to our channel, where we share edited educational segments from publicly available courtroom live streams. Our goal is to offer viewers a clear, respectful look into the day-to-day operations of the legal system. Through selected video excerpts and added commentary, we aim to increase legal awareness and help the public understand how real courtrooms function. Each video highlights roles and interactions of judges, attorneys, and subjects under review, with a focus on process, fairness, and professional conduct. We maintain a neutral and informative tone, avoiding sensationalism while emphasizing the importance of due process and courtroom decorum. Whether you're a student of law, a concerned citizen, or simply curious about legal proceedings, our channel serves as a reliable resource for observing how justice is carried out in a structured and transparent setting. Thank you for joining us in promoting legal education and civic understanding through real courtroom moments.
Just that one again.
Douglas called Pitts, Antoine Pitts.
Jennifer Douglas for the people.
David I. Goldstein appearing on behalf of the defendant.
He's not here.
Your Honor, Mr. Pitts is having some health issues. He has been recently diagnosed with lupus. He has a probation violation in front of Judge Hammoud. The public defender has been presenting to Judge Hammoud notices from the doctor regarding he's been ordered to bed rest and oxygen therapy. I was hoping to have him. I have several of them on my phone. I was hoping for a more recent one. The most recent one I have is from May, but they've indicated he has lupus and has issues with breathing.
Yeah, but we keep letting him out. He doesn't appear. The last time that you were here, I think I told you I was leaving the bench warrant out. I was waiting on medical. I never got any medical to indicate anything.
Okay, I can get those to
And I left the bench warrant out. And now he goes through the arraignment process, gets released again, supposed to get to community corrections, doesn't go.
Your Honor, I'm assuming he's not going because of his medical problem.
I don't know that.
I was okay. I'll get that stuff to you, Judge.
And
I've got some.
I already issued this bench warrant.
Yes.
He's already got a bench warrant outstanding at this point.
Okay, I'll get the medicals to you as soon as I can, Your Honor.
All right. So I'm just going to leave the bench warrant out. I'll give a new date on it, but July 3rd. And if he shows up, he shows up. But otherwise, in the interim, there's a bench warrant that's outstanding.
And you'll have the medicals before then, Your Honor.
Recalls the case, People versus David Witherspoon.
Joe Simon on behalf of Mr. Witherspoon, Your Honor. What's your name again, David? David Witherspoon.
All right. The issue in this case is I did call over there are no other violations, correct?
That is correct. One you missed. There's no late test.
There was a late test yesterday. Why?
It was 7 minutes. Well, I asked my client and he basically told me he was worried he was going to go to jail today and he was just.
Well, he should be.
Yeah, because I told him to be. And, but anyway, he has he missed the time slot and then just no good explanation other than he just missed and then he panicked and tested 7 minutes later. But he also wants to let you know he tested this morning too. And there was no violation.
Anything you want to say regarding this bond violation? Because I don't even understand.
He had a bad day and night where he's going to admit drinking alcohol. So that was June 3rd, segue into the morning hours of June 4. And since then, he's been completely compliant other than that 7 minutes. He also wanted to go over to a scram tether because he's so panicked about missing times, etc. He's maintaining that since he'll admit to drinking on the 3rd, but since he's been completely sober. Also, regarding the case, we've reached a resolution between the parties, but I just checked with Mr. Heaton, who was here today from the 14A court regarding sobriety court screening. And I know what my client needs to do. If we resolve the matter the way that we principally constructed, I want to get my client screened and accepted into the sobriety court in 14A first. And I think that will only help him in his issues. If in the interim he can be on a scram, and if all of that is acceptable to the court, I'd request July 17 because it's going to require a few things for him to get done before being accepted.
Mr. Allen, I will adjourn the probable cause to July 17th, 2025, 9 a.m. The defendant having admitted to the violation, I'm going to sentence the defendant 7 days into Washtenaw County Jail. So he'll be released and then can do that upon his release. He's to be placed on a scram tether prior to his release.
Thank you. So, Your Honor, my staff will try to make arrangements with the community corrections in my absence to make sure that he gets that before release. But in the court, as the court knows, sometimes we have trouble with that. Is there anything?
we will prepare an order that needs to be placed on the screen prior to release.
I'm saying for community corrections, the jail always is aware of that, but sometimes community corrections doesn't know to do that. You know what I'm
They're
saying?
supposed to be contacted, I think, by the jail. That's how that's supposed to happen. But
I've had trouble with that before. We'll do all we can. Thank you very much, Your Honor.
if you have an issue, let us know.
Thank you, Your Honor. That was July 17th. Thank you.
Yes. Court calls the case, recalls the case, people versus Alicia Henderson.
Andrew Bannis for the people.
Are we ready on that?
I'm gonna say no.
Court calls case, people versus Dantes Williams. Are we ready on that one?
Yes, Your Honor.
Well, they call for him. Court does, well, that one's coming out. Court calls case, people versus Sheldon Lewis. Is that? This is on the bus.
Yeah.
Sheldon Lewis? Oh. Was he driving the bus? Yeah. Or he wasn't driving it.
You're ready on this matter, Your Honor, and here he is.
Here he is what?
He was on the bus and he came.
I know. Did he leave all of his pants on the bus?
Yeah.
We won't have that happen again, will we?
Assistant Public Defender Constable Basie on behalf of Mr. Sheldon Lewis, who was present to my right. And you say fully for the record, please.
Yes, Sheldon Lewis.
Your Honor, we're going to be requesting an adjournment for some video discovery that our office has not yet received.
July 3rd, 2025, 9 a.m.
July 3rd.
All right.
Good morning, Your Honor. Kirma Dadish on behalf of Mr. Lester. Lester, can you please state your name for the record?
Yes, Paris Lester.
Okay, so Mr. Deuce, let me explain something about what she did. So she didn't know what a shortstop was the last time we were here.
I have a
I did,
diagram.
hold on. I then sent you a baseball diamond with all, yeah, you got it.
I have a diagram for you
Uh-oh.
for a game that you won't understand.
Oh, no.
So now she wants to play games with me.
That's what baseball looks like to me.
Wow, I'm sorry.
I appreciate that. It's Yellow's turn.
I don't even know what that is. That's what baseball looks like to her?
Looks like a house.
Okay, so I sent her a baseball diamond with all of the positions listed and their number next to them. She's showing it.
Mhm.
The response I get back, I was trying to help her, was she called me a troll. I'm just,
I never said those
no, I'm
words.
just pointing that out what you did.
I never said.
No, nope. You want an adjournment?
Yes,
Yeah,
please.
you may.
There are pending charges that are waiting to be authorized, so we are joining.
Additional charges against this defendant?
No, never. Yes, again.
So where are they in, do we know where they are in the system and how?
Your Honor, we have the warrant request, but I have to go through them. There's 3 or 4 of them.
There's 3, okay. And is this then the only thing holding him at this point? No?
No.
All right. Well, what I'll do then is I'll adjourn it out. Let's see where we are. I'll just go 2 weeks out, or basically 2 weeks out to
Okay.
July 3rd, 2025.
And for the record, Your Honor, we are, on his other cases, we are potentially working with CMH.
On
Right,
those.
yeah, okay.
Got it.
Thank you.
All right. And at this point, it's bond will continue. All right. Thank you.
Yeah, please.
That's. Oh. I don't even know what that name is. That's what she gave me. It's some voodoo stuff. Court goes case people versus Dave Ellington. See, I was trying to help her out.
And Jennifer Douglas for the people.
You know what a shortstop is, right? Oh, okay, never mind.
Welcome back, Mr. Allen.
Wow. She said, welcome back. She did? Did she miss you? Huh? Why did she say that?
What? I
There's
just
something
was
there.
acknowledging.
No, something's up. She's-
Your Honor, we are requesting a 2-week adjournment for mitigation purposes.
Any objection from the people?
Okay.
Probable cause July 3rd, 2025, 9 a.m. Bond continue.
July 3rd, 7-3, 9 a.m.
Okay. Court does call the case of the people versus Tyler Redmond.
Andrew Dantes for the people.
Good morning, Your Honor. Intern Malaika Fatima requesting to practice under MCR 8.120 under the supervision of the Deputy Chief Public Defender Lauren Brown.
Oh. It's a bald head. Permission to practice is granted.
Thank you, Your Honor. Appearing with and on behalf of Tyler Redmond, please state your name for the record.
Tyler Redmond. Thank you, sir. All right, what are we doing?
At this time, we are requesting an adjournment to be assessed for the Drug Circuit Court, which is set for June
The
20.
Drug Circuit Court.
The Drug Treatment Court. Yeah,
Circuit Court. I don't know what that means.
Circuit Drug Court.
Okay, go ahead.
It is set for June 26th, so a date after
So
that.
they would be, they have their meeting on the 26th.
Yes.
Okay. Any objection from the people?
No, Your Honor.
July 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Bond continue. What's she do? I haven't enough to sign. Trying to be fancy. Oh, you got it. Court does call the case people versus Latosha Griffin.
On behalf of Ms. Griffin, can you say your name for the record?
Latasha Griffin.
Latasha Griffin.
Your Honor, we are going to be setting this for preliminary examination, please.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available. The first preliminary examination in person, July 1st, 2025, 9 a.m. That is before Judge Perry. Bond continue.
Thank you.
Court does call the cases of the people versus Leo Stringa.
Andrew Dantes for the people.
Hannah Mackey on behalf of Mr. Stringa, who is approaching to my right. Please state your name for the record.
Leo Stringer.
Your Honor, we're respectfully requesting an adjournment to write up a plea offer form.
To do what?
We need to write a plea form.
Is this the only thing holding him?
I
Why is every question I ask her a mystery?
Feel the same way sometimes, Your Honor.
Uh-huh.
Said I feel the
Your
same
Honor,
way
it's
sometimes.
Wow.
It's not the only thing holding him in this county.
Pardon?
He has other holds in other counties.
Other
But in
places.
this
In
county,
this county, this is the only.
Probable cause conference, July 3rd, 2025, 9 a.m. Bond continue. Did she give me a green sheet?
Oh.
Do you have a green sheet? Or you're just gonna hold it?
No, I'm gonna fill it out.
Oh, you haven't even filled it out. Okay, so the correct answer to that would have been no.
Green sheet. Technically, I have a green sheet.
This is like riding that bus. Demetrius Griggs?
Alexander on behalf of the people, Your Honor.
Stephanie Can on behalf of Ms. Gray.
Ms. Griggs, could you please state your name for the record? Demetrius Griggs. And Your Honor, we are just setting this for a preliminary exam.
Discovery complete.
To my knowledge, Your Honor, yes.
People have their witnesses available the first.
We'll do our best, Your Honor.
Preliminary examination, July 1st, 2025, 9 a.m. That's before Judge Barr.
7 a.m. before, it's here.
I understand what?
Yes.
Bond will
9 a.m.
continue.
Nine.
Thank you.
Thank you.
Court does call the case People versus Larry Hickman recall.
Thanks for the people, Your Honor.
And good morning, Your Honor. Assistant Public Defender Chinazi Kariaki on behalf of Mr. Larry Hickman. Mr. Hickman, could you state your name for the record, please?
All right.
Your Honor, today's date and time set for a probable cause conference in this matter. The people did send over an amended complaint. I think he would need to be arraigned on the additional
Yes, he needs
charges.
to be arraigned on counts 3 and 4. So you do waive their formal reading.
We do waive formal reading of that, Your Honor. We stand mute, asking the court to enter a not guilty plea on Mr. Hickman's behalf.
All right. Defendant having waived formal reading, standing mute to counts 3 and 4. Court will enter a not guilty plea.
Thank you, Your Honor. And in regards to the probable cause conference, we'd like to set this matter for preliminary examination, Judge.
You want this set for the prelim?
Yes, please.
And you're satisfied with discovery, even with the added counts?
Yes, we are, Judge.
All right. People have their witnesses available the first. Preliminary examination will be set July 1st, 2025, 9 a.m. That's before Judge Perry. Bond will continue. Thank you.
Thank you, Judge.
Court does call the case of the People versus Alicia Henderson.
As we close out today's courtroom session, we're left with a clear impression of how the justice system balances procedural structure with the realities of human circumstances. Presiding over the docket was a judge who, while not named in the transcript, conveyed a commanding presence, direct, sometimes sarcastic, but firmly grounded in legal responsibility. His demeanor was not without moments of sharpness, especially when it came to issues of tardiness or vague justifications for absence. Still, he demonstrated procedural fairness, allowing space for defense counsel to make their case and for matters to proceed efficiently, even if reluctantly at times. One of the most notable exchanges involved Alicia Henderson, who was not present at the time of her scheduled hearing, represented by Assistant Public Defender Tanasia Carey. The court was informed that Ms. Henderson had a medical appointment related to her pregnancy. Carey presented the information respectfully, requesting a brief delay to obtain a more precise arrival time. The judge responded with unmistakable skepticism, remarking dryly that he did not find the explanation particularly persuasive. Nonetheless, he granted the request to pass the matter temporarily, a decision that, despite its tone, reflected a willingness to allow additional time rather than issue an immediate bench warrant. Carey's handling of the situation was commendable. She remained composed, professional, focused on achieving a reasonable outcome under difficult circumstances. The case of Dantes Williams, represented by Hannah Mackey, was managed in a quieter but equally procedural fashion. Williams appeared in court and responded clearly to the judge. His attorney requested that the matter be passed for coordination with a bond-related motion to be addressed later. The judge agreed to the delay, again showing a pragmatic approach to consolidating related issues. Both Mackey and her client demonstrated preparedness and adherence to courtroom expectations. In contrast, the case of Marcus Jones, represented by April Orkestum, has brought a more collaborative tone to the hearing. Mr. Jones explained that he was about to begin outpatient. Treatment through CMA to regain medication compliance, a significant step in addressing underlying issues. His attorney requested a 1-month adjournment to allow time to show meaningful progress in treatment. The judge, while initially working through calendar limitations, ultimately granted the adjournment and continued the bond. Jones was respectful. In his responses, and his proactive engagement with treatment was noted without critique. This case illustrated how the court can accommodate rehabilitation efforts, provided the intentions appear sincere and the communication is clear. While no witnesses or officers testified during this session, the work done by attorneys on all sides played a pivotal role in guiding the flow of each matter. Tanasia Carey, Hannah Mackey, and April Orcostume each presented their arguments with clarity and professionalism. Even when navigating complex or imperfect client situations, the courtroom tone remained calm overall, but with intermittent spikes of tension brought on by judicial frustration, particularly in moments of perceived excuse-making. Still, the judge's ability to maintain control while allowing each side to be heard ensured that proceedings remained within the bounds of due process. Today's hearing is a valuable reminder that courtroom effectiveness depends not only on rules, but on how individuals respond to pressure, preparation, and expectations. Judges' decisions reflected a desire to uphold order without acting rashly. Attorneys performed solidly, particularly when facing absent or late clients. Participants like Marcus Jones showed how accountability and rehabilitation can coexist. Within the court structure, if you found this hearing insightful, consider subscribing, turning on notifications, and leaving your thoughts below. Your engagement helps us continue to share respectful, educational views into courtroom dynamics, fostering legal awareness for all.